Welcome to the weekly Saturday knowledge sharing webinar organized by Mehta and Mehta. Thanks all of you for participating. Today's topic is masterclass on issue of securities and insight into issue on private placement and preferential basis. I will say maximum question, maximum issue, maximum practical problem in this topic. We get repeatedly every week 2 or 3 minimum query or questions on this issue. So I know though participant will be affected today, as I was discussing that today is a budget. We are sorry that, but we will post this in YouTube. Every participants regular can attend. And also if you have questions, please post on it. We will discuss with our panelists and we'll share with you. Surely that is a commitment. So I'll not say much word because our panelists want to say much more thing. So today's our presenter is Ms. Khadija Indorwala. She is an associate member of ICSI and Commerce and Law graduate. She is having 5 years post-qualification experience in corporate secretary and legal field. She specializes in due diligence, secretarial audit, and handling compliance under various laws of the Companies Act. See, our panelist is Mr. Ranganathan today. He is be a panelist earlier also in our webinar. We are fortunate to have him again. He is a corporate law advisor. His earlier stint were with Edelweiss Financial Service and the Tata Group. He is a fellow member of ICSI, ICMA, and a lawyer. He has 33 years of experience in the corporate field encompassing investment banking, governance, company law, corporate restructuring, NBFC, ERC, and allied corporate laws. Very wide variety of experience. He is a member of a Secretary Standard Board of ICSI. He was a member of Company Law Review Committee constituted by MCA to review Companies Act 2013. He is a senior faculty with various business schools, professional institutions, and has conducted sessions and presented papers in various forums, both in India and abroad. Welcome, Mr. Ranganathan. Thanks a lot for your time. Thank you very much. We have with us Ms. Alifia Sapatwala, partner Mehta and Mehta, Mr. Bala, Professor Bala, we would like to say, and Mr. Sudhakar. No need introduction. And straight, I will go to our panelist for today's webinar, some introduction. He would like to say a few words on the topic, then Sudhakar, then Bala, and then Khadija, you can start your presentation. Over to Mr. Ranganathan, please.
Good morning, all of you, and good morning, friends. Good morning, Sudhakar, Bala sir, Deepti, Atul bhai. I don't know whether he attends, but thanks to Atul bhai too for inviting me. And second time you invited me, Deepti. Earlier one was on mutual funds. Okay, thanks a lot. And that was a webinar you missed. Okay, I still remember. So you missed. Fine. So thanks a lot once again. And as you rightly said at the beginning, this is a very, very complicated topic in the sense looks very easy. It's like FEMA. When you read FEMA, it looks like, simple things. But when you start practicing it, why did I take this practice is what you will feel. So it's that kind of a topic is what Sudhakar has given to me to dwell. So let's see, because as Bala sir said, he is invisible and we are all there to support each other. So a lot of practical questions, even I have certain things which, we have to mull it over because you don't get a direct answer, friends, for most of the things. Fine. As as a fraternity, we need to take up some views on certain things, and that's how we should proceed. So the topic which is very interesting is, all of us as company secretaries, in our experience, in our, whatever career, in our career, rather experience, the career, we all want to handle two major things as a company secretary, other than whatever the normal board meeting was. But two things. One, fundraising activities in any form, in any form, fundraising activity, and second thing is on mergers and acquisitions, corporate restructuring. I think every one of us would want to handle this at any point of our career. And fundraising activity, why I'm emphasizing is, and the company secretaries of fraternity is more of a primary issue, guys. And that's why we focus on, because it's only in the primary issue that you have a lot of regulations, in place. Others are in the secondary market. If you see, it's all more of operational things. Here is a place where we as professionals can execute. So the topic is very interesting. Private placement of, the securities. We'll see how best we can do. Just to tell you, as I would reiterate that though the topic is preferential issue and much lesser time consuming than what an IPO does, it's hardly you can finish off a preferential allotment, within a matter of say 30-35 days, unlike a public issue. And secondly, you need not have to file this with any regulator. I think that's the biggest thing with SEBI. That's the biggest thing in case of listed entities that can happen. But we also have to understand, while we start the topic, when Khadija presents, I will also talk on the genesis of Section 42 is also very important for all of us to understand. Maybe I'll just spend a time with your permission, Sudhakar and Bala sir. I'll just spend a minute on this. Earlier in 56 Act, we had one subsection called the 67(3), which talked about any offer to more than 49% will be deemed to be a public offer. And we all know what had happened in 2009, and of course, in 2012 also, the Sahara and the Sharda episode. And the genesis of all these things goes back to the Sahara episode. My request to all of friends who are on this is, once in a lifetime, we should read the Sahara order, the original Sahara order passed by the whole-time member, dated June 23rd, 2011. It is all of us for us to, if we want to understand what is securities market, and if you have to be in this fraternity, I would always urge all of us should read at least one. So that's the genesis. And then Section 42 was separately introduced as a part of the Chapter 3 of the Companies Act 2013. And that is where we stand today, and a lot of ifs and buts and a lot of restrictions in how do you complete a preferential offer and a private placement. So with this small introduction, let me hand it over to others, please. Thanks a lot.
Yes, Sudhakar.
Yeah.
Thank you, Mr. Rama.
Hi, good morning, everyone. And further to what Deepti has introduced to Mr. Ranganathan, I must say that he is one of the finest professionals whom I come across. And at our first meeting itself, he said that, don't call me Ranganathan, call me Ranga. It took me almost 1 year for me to call him as Ranga. And during that 1 year, I used to call him as Ranga sir. He said, I won't allow you to call me as sir also, but you call me as Ranga only. So it almost took me for 1 year, because such a knowledgeable person, how can I call him as Ranga? Even in case of Bala also, the same thing had happened with me, because Atul Bhai, Deepti, they all used to call him as Bala. Then I say Balakrishnan or Professor Balakrishnan. It seems to be that, I have to keep him in a different pedestal altogether. So this is the kind of professional intimacy we have towards each other. Coming back to the subject, as Mr. Ranganathan has rightly mentioned, as far as Sahara case is concerned. In fact, if you see the Companies Act 2013, there were three major genesis, the scams which have taken place. One is the Satyam, second one is the Sahara, and third one is the Sharda chit funds case. I used to always call in my presentations as Satyam, Shivam, Sundaram. So in that, Shivam is the Sahara case. And in fact, that Sahara case is the genesis for this kind of stringency what has been brought in Section 42. Initially, if you see the Section 42 as well as the rules thereof, it was such a difficult proposition, which was next to impossible to implement that. Courtesy Companies Amendment Act 2017, the section was entirely substituted by new provisions. A lot of relaxations have been given in the rules thereof. However, please remember that Section 42 and the rules thereof is more of procedure oriented. And this procedure also, that meticulously it is to be complied with, because any kind of non-compliance will affect the issue altogether. Say, for example, the letter of offer and the application attached to that is to be circulated to the identified persons in PAS 4. who are the identified persons and who has to identify them? It is the board which has to identify them. How the board will identify? It is by virtue of the board resolution itself that they have to be identified. So in the board resolution, when you are drafting it, you have to be very careful and you have to ensure that those people have identified in the resolution itself. Second thing is that class 4 cannot be circulated unless until that board resolution or the shareholders resolution is filed with the ROC. Only thereafter you can circulate it. Before that, you cannot circulate it. Similarly, after allotment also, you have to file PAS 3 with the ROC, and unless until you file the form, you cannot utilize the funds. So these are and the form is to be filed within 15 days, not within 30 days. This, according to my memory, this is the only form which you have to file within 15 days. So what my submission to the participants is, according to me, handling an IPO might be slightly easier than handling a private placement or a preferential issue. Because why I'm saying this thing is, in case of a IPO, there is a merchant banker who will take care of the responsibility to a large extent. The responsibility of the company to in comparison with the private placement is lesser. Whereas in case of a private placement, there won't be any kind of merchant banker. It is to be done entirely by the company and by the compliance officer only. So whenever you are handling any kind of private placement or preferential allotment, be meticulous, prepare a good checklist and ensure the implementation of that checklist meticulously so that you won't indulge in any kind of non-compliances. Similarly, several times this question comes whether the valuation certificate is required only for preferential allotment or for private placement also it is required. Because for preferential allotment under the Companies Act, the procedure prescribed under Section 42 is to be complied with. Because of that, several times this question has come up. So I give a pause here and over the presentation of Khadija that we will discuss it further and give it back to Deepti.
Yeah, Mr. Bala, 1 minute for that because everyone is waiting and then Khalil will start.
Good morning to all of you. I have a great pleasure in welcoming you all on this budget day. Initially, Dipti was actually a little bit doubtful that our attendance and other things are all going to affect. Even though there is a budget, the number I can see is about 156, which is registered. That itself shows what is the importance of this particular topic. Already our earlier panelist has elaborately said many things. According to me, I will only say one small thing. Either you talk about the private placement or you talk about a preferential offer. Both are actually capital raising only. But the only thing is these are all coming in the different mechanism. When you talk about the different mechanism, what difference between these two sections make? Basically, the two sections make the difference because of the security definition. Because if you look at the definition in 42, it actually talk about equity share and convertible and compulsorily convertible equity share. That is why it's talk about it. But whereas the other section talk about including non-convertible compulsory shares as well. So that means what happens is according to that, the rules application differs. Because when you actually go to the section 62, it is again, you know, what happens is the section appears actually along with the Companies Act, the shares debenture issue rules it applies. But when it's come to 42, it is prospective and allotment rules applies. So as we being a professional, we look actually, as Sudhakar puts it very clearly, what is the methodology, what is the security is offered, accordingly the checklist is to be prepared, that is number one. Number two is, as Sudhakar puts it very nicely, there is nobody to take care of you like a merchant banker in the IPO issue. So everything is to be done by the professional itself. So that makes the more difficult for us how to comply with that, because he has already touched upon many compliance issues which are actually related to this. So I stop it here because people are eagerly waiting. We'll go along. We have an expert because Ranganathan himself, I know, he handled many such issues. He has got a practical insight of it. I think during the course of the time, he will actually share with all those experiences, etc. I am also equally looking forward to hear from him. Over to Khadija, please, your presentation.
Okay. Good morning to all the panelists. Thank you, Dipti ma'am, for such a nice introduction. Now we'll start with the PPT. Here, different methods to raise capital. That is public issue, right issue, bonus issue, private placement, and preferential issue. So today we are going to concentrate only on private placement and preferential issue. So moving towards private placement. Which section governs? Section 42 and read with Rule 14 of the Company's Prospectus and Allotment of Security Rule 2014. For preferential issue, Section 62 read with Rule 13 of the Company's Share Capital and Debenture Rule 2014 and Regulation 158 to 170 that deals with preferential issue in the case of listed companies for as per SEBI ICDR Regulation 2018. Private placement. Private placement means any offer or invitation to subscribe to a select group of persons. Now, here select group of persons are known as identified persons also by a company through a private placement offer cum application letter. That is PASFO. Now, offer shall not be given to more than 200 in aggregate in a financial year. Now, while counting 200%, we need to exclude qualified institutional buyer and employees to whom allotment is made under ESOP. Deem public offer. If offer or allotment is made to more than 200% in a financial year, it shall be deemed to be a public offer.
Sorry to intercept, Khatija. Sudhakar sir, can I intervene
Yes.
in
Yeah,
the
please.
slide, or is it that entire presentation is to be completed?
Anytime, please.
Please,
Anytime.
Please hold on, please.
Yes.
Please, sir. So good, Bala sir, you touched upon. I think we are all, what do you call, concerned about private placement and preferential offer. It's a very simple to put it, friends. Everything is private placement. That's the umbrella. Within that, you have this preferential offer. It is like what you have, the non-executive directors. Within that, you have so many guys, right? It's similar to that. Private placement is a broad category. The only difference that we need to understand, because every time, including very experienced people, come across this small doubt, of course, worth discussing that. So is that, as Bala sir rightly mentioned, in case of a preferential offer, I think it's covered in one more slide as well. It talks only about equities and convertibles. That's all. But 62 has to be read in conjunction with 42, which talks about the process that needs to be followed. So again, you fall under that private placement umbrella. Now, the only difference under 42 is securities. That means you can also issue non-convertible debentures under section 42, and it's not governed under 62. I think simple way, and Bala sir had also put it very nicely about. Thank you, sir. That's one. Now, when it comes to second issue, which I encounter, others can please correct me if, so it talks about very clearly, initially when the Act was enacted, it talked about number prescribed and or more than 200. Now it is 200. Every time, I encounter this question, Sudhakar sir, is, basically they are saying in a financial year, you cannot issue more than, not at one time, you cannot issue 50. In a financial year, you cannot issue more than. Is that the correct interpretation? The rules are also very clear. In a financial year, for a particular instrument, the number of offerees should not be more than 200. There is no question of 50 and 200. It is 200, friends. Is my understanding very clear? So Sudhakar sir, if you have anything, please. Unmute kar lo, sir. Unmute karo. Hello.
So the 50 was under the old Act, and
Yes.
in the new Act it was mentioned as may be prescribed. And if we refer to the rules, in the rules it said 200.
200.
In fact, in the old rules, prior to Companies Amendment Act 2017, they said that not more than 200. They are not set security wise. With that, what happened was, in a financial year, if you are issuing equity shares, or if you are issuing convertible debentures, non-convertible debentures, all together you cannot exceed 200. That has put into a lot of difficulties Fortunately, under the Companies Amendment Act 2017, which has come into effect somewhere in August 2018, I think, the rules have also been changed accordingly. Then they said that this 200 is per security. That means it is per equity share, per preference share, per convertible, non-convertible debentures, like that it is. So that is what the thing is. It is 200 instrument-wise in a financial year. That means if 24-25 financial year, if I am able to issue 4 different type of instruments, my ROM can be about 800 people. Again, 26-27 financial year, sorry, 25-26 financial year, again, I can have a fresh 200 multiple by the instrument which I'm going to issue. That is what the thing is.
Yes. Good, sir. Good, good. So this one question which I think everybody is grappling every now and then, and that's the reason I just posed this for the first time. Secondly, when you count the number of 200, you had very clearly 42 talks about two exceptions which are for QIBs and the ESOPs, when shares are allotted under ESOPs, that is also exempt. But one more thing we need to be mindful of: if you're an NBFC, if you look at the rules, NBFC and housing finance, companies. Now, housing finance, of course, has merged with the RBI guidelines itself. So, there, the NBFC directions, I think it came sometime in 2015, it very clearly distinguishes, in two ways. NCDs, that only talks about NCDs and not equities, shares or convertibles, only NCDs. Now, that talks about per investor, if an issue is made to particular investor or a per investor if the value is less than 1 crore and more than 1 crore. Now, if a NBFC or a housing finance company is offering NCDs with the value or with the face value of the, with the value of NCDs exceeding 1 crore, then there is no limit, no bar on number of investors subscribing to it. So that is another thing which I just wanted to point out at this stage, friends. So apart from this, if you look at NBFC and FSM, housing finance companies, you have this exception too, if it is more than 1 crore per investor. Over to you, Khadija.
In this
One
slide,
more.
1 minute, Khadija, please go back to the slide. In this slide, one more important thing is that I select a group of persons within brackets. Khadija has mentioned identified persons. Please remember that this selected group of persons are to be identified by the board of directors. As I told in my introductory remarks, I want to re-emphasize this particular point. The reason being, God forbids, if any investigation or inspection takes place, if I am the regulator, what I am going to do is, I am going to see your PAS-4 and the applications what you have circulated and the applications what you have received in the private placement offer. I'm going to cross-check that with your board resolution. And suppose several times some people ask me this question, sir, suppose if I am going to issue to 190 people or exact 199 people, am I going to put all their names in that resolution itself? Not necessarily, but you have to say as per the list placed before the board. That list is to be part of your what's called board supporting papers. And you have to mention in the resolution as per the list placed before the board, identified by the board, to whom the PAS-4, that the a letter of offer together with the application is to be sent to, initialed by the company secretary for the purpose of identification, or initialed by the chairman for the purpose of identification. That particular resolution you should be able to produce before your investigation people or inspection people, whoever are coming to that. In case you fail to do this, it leads to a non-compliance of Section 42, and obviously the penal consequences will get affected. Same is the case with PAS-3 also, because see, that's what I said, that handling Section 42 is very, very difficult, because in PAS-3 also what happens is, there is a requirement that the application money has to come from those accounts of those applicants only. In case prior to this, what used to happen was, if I am putting an application in an IPO or rights or whatever it may be, the application, the check what I'm attaching may be from anybody's this thing. As we initially started with the Sahara case, in Sahara case, if you go through that case, you will come to know the applications were all by somebody, whereas the application money was received from somebody else. That's why in Section 42, there is a clear-cut requirement that the application money has to come from the applicant's bank account. in case of any inspection or investigation, forbid that, God forbids, if it happens, this is going to be cross-checked. So please, as a compliance officer, you have to be very meticulous when you're handling Section 42. I used to, when I was in RIL, that time I used to get really scared, okay, by Section 42, whether any kind of non-compliances should not get this thing. So we used to have a very, very robust checklist for while we are, because we used to have obtain number of issues within the group itself, as far as Section 42 is concerned. Yes, Khadija.
Yeah, I will add one thing, not only investigator agency, but secretarial auditor.
Yeah,
Because then be ready for qualification. We cannot
correct.
walk backward. Okay.
So that means, Deepti, what you are trying to say is not only from this side, that means in the employment side, but in the secretarial auditor also having a great responsibility, because before you give a clean report to your client, you have to ensure if any private placement is there, this is how you have to check it. Correct?
Yeah, this all we need to check for the compliance.
Absolutely.
One more thing I just wanted to add, nowadays everything is on digitalizations. So there are many private platforms, they offer actually that we'll actually offer you in getting your private placement, we will actually use the digital platform, we will actually send out the letters, etc. via email, all such things which are actually happening. So you have to be careful here to ensure that number, because the number of the recipient to whom you get it in the digital platform, that goes havoc. Because there are cases like that, heavily people have been actually penalized. There are issues are like that. That is one thing one has to be very careful when you are actually utilizing a digital platform. Everything is good in the digital, but at the same time it has come the disadvantage. That is the number one. Number two, at time what happens is people think, okay, it is restricted 200. We actually create intermediary. We issue selected group of people to the other company. That company in turn issues the many people which exceed the number. There are cases also there in this. So one has to be very, very careful. As Sudhakar puts it very clearly, there are nitty-gritties, all these things. You have to work with the checklist, ensure the compliance at the end of the day. Yeah.
Good, and especially just to add to what Bala said now, this downselling by an intermediary like a PMS guy and other things, there are a lot of cases which SEBI has come very heavily on this. And that too, friends, downselling, please be careful not to do that within 6 months of that allotment. I think that's a clue. You should never do, at least within 6 months. Itna to dhyan rakhna padega.
Yeah, in fact, in Hyderabad, one of the private placement company, I think if I remember the company's name, it was some pay slips or something like that. In that company, the same thing has happened, and the ROC has heavily penalized that company. That's the thing. Yeah.
So it's an instruction, no downstream selling by appointing intermediary, issue to intermediary, and that intermediary further transfer. Very clearly mentioned. So as a secretarial auditor also, we are clarifying.
Yeah.
Yeah, please go ahead.
Now, securities of which private placement can be done, that is shares, equity shares, preference shares, and preference shares CCDs, and debentures, convertible debentures, NCD, as discussed by Sudhakar sir and Ranganathan sir, OCD, and partly convertible debentures. Now,
Two
what
things.
are
Khadija, 1 second. Just go back.
Yes.
Go back. Two things. The smile shows that each slide will have something to talk about. Yes. Chalo. I think you covered almost everything. Two important things, or OFCD, which was the entire Sahara episode was on that instrument, right? The optionally fully convertible debentures. Second thing is, if you look at, the warrants is also one of the instrument which is coming under the thing. So, we need to just, you can add it later. You can just add it later. Okay, go ahead, please.
Now, before initiating for private placement, what are the perquisites or process we need to take care? That is, no further fresh issue can be done unless allotment for previous offer are done. Earlier offer is withdrawn. Earlier offer is abandoned. Identify the person to whom the securities are to be issued on private placement basis and get the valuation report. Now, in valuation report is mandatory in case of issue of security on private placement, both for valuation at price at which securities are issued and valuation of the consideration when securities are issued for consideration other than cash. Valuation needs to be obtained as on the relevant date, that is the date which is at least 30 days prior to the general meeting to be held. Valuation report is not required in case of NCD as it does not involve conversion into shares.
Okay. Can I add, please?
Yeah.
Okay.
Yes.
So, one point, it's a very major point that of late I'm coming across, especially in listed space, of course, two things. One, I think the act is very clear in case of unlisted companies. Valuation is a must, whether you do, whether it's a shares or accept the NCDs. Valuation is a must, whether you do it for cash or you do it for consideration other than cash. I think the act and the rules are very clear in these things. But now coming to the point of consideration other than cash. Normally, even if you look at that rules, it talks about if it is an amortizable asset, then it should form part of your, that is, you get what you call, you debit the asset and credit the share capital. That's how it talks about, right? But in case of other one, it is what do you call into the expenditure as per the accounting standard. These are the two things which are mentioned. Of late, what I'm getting coming across is what I'm coming across is can I convert, for example, one very recent case which I came across, Deepti and others, I just want to tell you, and you have been insisting on secretarial auditor, so be careful with this. So, like the question that comes is a company is owning a lot of money to a creditor. So trade payables, in fact. They are asking me whether, instead of paying cash, can I issue shares against that? Okay. The second one is, the MD wants, some heavy bonus to be paid for himself, but the, company doesn't have money. Can they issue shares against that? Third one, 3 months salary we have not paid to the employees. Can I issue shares against this? These are the things that are, because I always feel, Indian entrepreneurs have seventh sense. All this jugaad can happen only here. And hence, this was, one second. And this was the only, so if you look at the listed space, there was an amendment to regulation, I think 163, I think, which very clearly talked about if at all, if it is for consideration other than cash, it should be against swap of shares. Because there was a very famous case, I'm forgetting the name, I think I'm forgetting the name, because they wanted to, pay the creditors, the trade payables against some pulses. It's a pulses company, and very clearly SEBI negated this. And that's why this amendment came in the ICDR saying that it should be the only thing that could be done is if it is an unsecured loan, it could be, and you can convert that into equity shares, provided you follow section 62 subsection 3 clearly. In one case where I'm encountering is they have passed unsecured loans, etc., but they have not given that option to convert it when the special resolution was passed initially. Now they are struggling. So please, let's be mindful of this, friends, that these are the things which are happening in, a company wants to purchase shares of another company. Yes, it can be done. Recent examples, there are many examples, friends. I don't want to name the companies. You go to NSE, BSE website, you will get, I'm acquiring, a company is wanting to acquire another company. It has to pay cash. Instead of cash, there is a swap of shares and, and it gives against the shares against this. Why this is? Even in takeover code, consideration, exchanging of shares are allowed even in takeover code. So be mindful of this fact is what I just wanted to mention when it comes to the valuation report. Second thing is, normally when you take, especially, in this case for consideration other than cash, when it comes to the listed space, you have two different pricing methodology for a frequently traded shares and for infrequently traded, not frequently traded shares, right? So frequently traded, you have the formula, you follow that, and the price cannot be lesser than the issue price cannot be lesser than that. But when it comes to the not frequently traded shares, you have to go through the valuation methods, arrive at a particular thing, and then the valuation. Two things which you should remember. For example, if I do that exercise and it turns out to be the market prices, let us assume it is at 300 rupees, but the valuation comes to only 57 rupees. Can I issue at 57 rupees is the question. Yes, as per the regulations, but the difference between 57 and 300, the regulators will come into, because it seems that the intrinsic value of the share is much higher than the book value, which the registered valuers would have considered. So be mindful of that fact. At least we need to bridge that gap is one thing. Maybe a difference of maybe 10%, etc. could be allowed. And I'm sorry, I'm not able to follow the chat box very quickly, friends. Otherwise, my flow will go. So please, we'll take this everything. So that is one thing.
Ranga, in the chat box, whatever the questions are there, Bala will take care after some time. Okay, you don't need to worry about that. No need to answer across.
Please. Thanks a lot, Sudhakar. So the third one, which is very important from all of us, friends, is now register valuer. Under section 247, the register valuer's appointment has to be done by the audit committee, right? You require an audit committee approval for that. Okay. Now, normally, if you see the register valuer's date of, this is very important, friends. I think food for thought too. I'm saying it's a food for thought rather than anything else. Now, he will date as of the date of the board meeting. He cannot. Now, whereas this guy comes into the picture much earlier when the idea was conceptualized that, you need to do a preferential allotment and it should be for a consideration other than cash. So how do we take his, especially in a listed entity, you will face this problem. The moment you take him, please put his name and the details in SDD. That's the first thing which you have to, because the work starts much earlier, right? And secondly, you can pass, I'm leaving it to everybody's wisdom, but you can pass an enabling approval of the audit committee. It's an enabling, we know how to draft resolutions without commas and full stops, right? So you can do that. You include all kinds of things, including the preferential issue, because otherwise it becomes difficult to justify how did the valuer gave this report when the board is considering this. These 2-3 points which I just wanted to highlight and maybe food for thought for all of us, friends. Yes, Khadija.
Just one or two things, that further what you have mentioned about for issue of shares other for consideration other than cash. That only thing is under the old act, what we used to do was whenever any payables are there by the company. Suppose if the company has borrowed the money or if the company has purchased something and all, when you have to make the payments, we used to take a letter from the concerned applicant that please adjust my proceeds against my share application money or something like that, which is not possible now because in case of private placement or preferential issue, if you see the procedure of section 42, the application money has to come from the bank account of the applicant concerned. So this consideration other than cash, unless until there is a tangible asset or an intangible asset is there, it is not possible. You cannot, utilize the payables towards the application money. Sweat equity is an exception that we will discuss it in the next webinar where we have ESOP and sweat equity. Okay. Yeah.
Okay.
Go ahead.
Good. Just only one second, Sudhakar. You mentioned a very good point about this, payables and application. But if you look at whether you look into table A or table F today, you cannot adjust money against anything other than what is there as a lien. That's all. I think table F is also very clear. Table A also was very clear. Just to add. So by the way, the things are going, Sudhakar, I think each slide will require a 10 minutes discussion.
Yeah, absolutely.
The topic itself is such, that's what you also said in the beginning. Because it's very easy to talk about the thing, but when it comes to 42 and 62, when the 42 come, when the 62 come, what are the procedural, even added to Dipti has touched upon the secretarial auditor's job, all the things are all getting its own nitty-gritty. Yeah. Go ahead.
One more second. One more. Sorry, Khadija. Patience required because we are doing a preferential allotment. So we need patience. Okay. So otherwise Dipti will qualify. Hence, we need to be careful on this. So, one more thing which we are talking about, that allotment to be done within 15 days under section 42. So, Sudhakar sir, if you look at FEMA, that gives a provision.
No, 1 minute. Allotment is not to be done within 15 days. Allotment is to be done within 60 days.
60 days.
The PAS 3 is to be filed within 15 days.
Only after filing it, you can utilize the money too. Okay, 60 days versus, I'm talking, yes, exactly. 60 days versus the FEMA talks about 180 days. So when a client sits before Deepti and asks, FEMA says this, whereas your Companies Act is saying this, why should I do this, will be a question for us to ponder over this one. Please, these are all some of the lessons, Deepti, since you are doing a very good job of, every week you are organizing so many things. Some of the, questions that you should make a manual and circulate to all of us for our gyan, for our knowledge, So I will help you in that.
Sure.
Okay, go ahead, Khadija. Kanji.
You are on mute, Khadija.
Now, as we discussed about the kinds and the private placement, identified person and everything, now what is the procedure that is mentioned in Rule 14 of the Company Prospectus and Allotment of Security Rule? The general rule for private placement is to pass a special resolution in the general meeting for each issue and invitation. Now, the explanatory statement annexed to the notice need to require the following: date of passing of board resolution, kind of securities, total amount to be raised, price, justification, details of valuer, contribution of promoter or directors to the offer, and material term of offer. Now, there is an exception which says that non-convertible debenture can be issued without passing a special resolution if the amount to be raised is within the limit of section 181C. Now, in case of NCDs, within limits of section 181C, the board resolution as per section 179(3)C shall suffice. In case of allotment to QIBs, a previous special resolution only once in a year for all the offer or invitation for all the allotment to QIB during the year is adequate. Now, the special resolution that is valid for only 1 year.
Okay, a couple of things, panelists, and here I have got 2 things. Somebody just posted, I could just have a quick glance at that. Is it necessary to open separate bank account? Okay, I would request Deepti also to put her views on this, please. One thing is, the act is very clear, separate bank account. If you look at dividend, it also talks about separate bank account, right? Now, every time, Sudhakar sir, the problem that we face is not we guys are very clear, but the treasury guys comes and says, boss, every time when I open, I have to close. This is a lot of difficulty and all those stuff. They try to prevail upon us. Why do you need a separate bank account, etc., etc. So you can have my only thing is some of the companies have resorted to this, Deepti. That is what I think you as a firm also should tell, guide the fraternity in some form or other. Like what they're trying to say, Sudhakar sir, is I will open a separate bank account in my first issue. I will, once the allotment is done and the money is utilized, that bank account lies as it is. So can I use the same thing for my subsequent issue is the question. Whether we can do this, but the nomenclature will remain, say, private placement or preferential account of XYZ Company Limited. I don't mention the year like what we mentioned in dividend, 24, 25, 23, 22, etc., etc. Whether this is a method which many companies are adopting to, and based on the pressure exercised by the treasury guys, and that's why somebody. In fact, I have also noted down this as one of my query. Separate bank account, opening of separate bank accounts is something which maybe if we know, we should guide, or maybe we should take some time to mull it over and give a proper answer. This is one. Secondly, when this question of limits comes under 181C and which normally there is a discussion. I think this is one. Whenever my limits or borrowing limits are crossing, I go under 181C and pass a resolution is the first thing which I do. Here the only thing that is being talked about is within that, if you had mentioned about anything about the NCDs, when you talk about the NCDs, if you have mentioned a sub-limit, And during that period, when you want to issue, if you see the paid up capital, if it exceeds paid up capital and free reserves, then please pass a special resolution, which is valid for a year. Otherwise, if it is within that, is what? Is there any confusion is what? And these are two things, Deepti, Sudhakar, Bala sir, Khadija, these are two things which every now and then everybody is asking. I think since we have taken this topic, I'm leaving it to you.
I can straight away answer your question.
Please.
As far as the first question is concerned about the separate bank account. And you said there is a pressure from the treasury guys. As a compliance officer, I don't like this kind of pressures, number one. Number two, my advice to all the compliance officers is that to resist this kind of what's called a tactfulness or pressures, whatever it may be. Because the other person, he don't want to do the hard work, so he is trying to put pressure on you. So don't budge as far as that is concerned. It is very clear that a separate bank account is to be opened, means the regulator is interpreting that a separate bank account is to be opened. Okay, so earlier what we used to do was, suppose if the bank account there is no funds left out, suppose if I can't change the caption of the bank account, that means whenever you are doing a private placement, you cannot simply say private placement account of so and so company limited. No, that is not the way how you have to open the bank account. Because the regulator, if he comes for an inspection, he wants to see that whether you have opened the bank account, when the funds have flowed in, from where the funds have come to that particular account, and when you have started utilizing that money, all these things, the audit trail is required. That trial can be happen only when there is a separate bank account and you close that account. The moment you are using that particular account for issue after issue after issue, this kind of audit trial is very, very difficult. So regulator mindset is very clear. You have to open a separate bank account. You have to close it as soon as the purpose is over. And you have to maintain the bank statements and everything, so that tomorrow, if any issue happens, you should be able to substantiate that. That is very clear in my mind. That I have told this in several forums also. People used to say that, sir, my accounts guys won't agree and all. I said, those days have gone. If the accounts guys don't agree and all, you are a compliance officer, you have a fixed responsibilities and accountabilities also. That is my first question. Second question is concerned about your 181 year 1C resolution is concerned. 181 year resolution primarily to what's called mortgage the assets of the company. Whenever
181C, sir. 181C only.
Okay. As far as 1C is concerned, if you have the borrowing power, then you don't need to go again. What it says is that the moment you have the borrowing powers under 181C, I don't need to go for enhancement of the borrowing powers. I don't require 181C resolution. But if I am issuing any kind of debentures or any kind of debt instruments, I need to pass a special resolution for issue of the debt instrument. That is valid for a period of 1 year. Yeah.
Okay. One second. Someone is asking, about the accounts, because sir, this is something which every now and then I think most of the we guys are facing this. I mean, when we say we guys, the fraternity is facing this. No. So can we have two accounts? He is asking operational investment account. I don't understand what is investment account in this case. I'm borrowing through NCDs. I'm issuing, where is the question of investment account coming in? I don't understand. What is operational
investment account? What he is trying to say, I saw that what he might be trying to say is separate account for this kind of private placements, preferential allotments and all. As I told categorically, that is not permitted.
And this is not operational. This is a one-time, this is a corporate action that you are doing. So it cannot be an operational one. Yeah, please.
Sudhakar very rightly said, actually. It is the question of, the compliance was convenient. That is the question which arises. You cannot live with the convenient. You have to comply with it. That's it. Yeah.
There is a comment. We will appreciate if explanation is also in connection with private companies, section 181C. I think we have given.
What is this? I'm sorry.
No. We will appreciate if explanation is also in connection with private companies, section 181C. It's all given.
I don't understand because he spoke elaborately on 181C.
181C. Yeah.
Yeah. So Sudhakar explained it very nicely about the borrowing power and when the resolution is required to be passed when you're offering NC. That also he explained very well.
Yes, Khadija.
Yes, please.
Yes, please go get.
Khadija, you are on mute.
No offer or invitation of any security under this rule shall be made to a body corporate incorporated in or a national of a country which shares a land border within India, unless such body corporate or the national, as the case may be, have obtained government approval under FEMA non-debt security instrument rule 2019 and attach the same with the private placement come offer application letter. Now, the board resolution, special resolution to be filed with ROC is within 30 days of passing of Form MGT 14. Now, the key points of offer come application letter, that is PASPO, is mentioned here. Should be in form PASPO, can be either in writing or in electronic mode, should be serially numbered, it's very important, and addressed specifically to the person to whom an offer is made. Not required to be filed with ROC, should be sent to the identified person only after filing a board resolution, special resolution with ROC in form MGT 14, as discussed by Sudhakar sir and Rangnathan sir. Should be sent within 30 days of recording the person name in the board meeting, general meeting. If the application is not made by the identified person, then such application will be treated as invalid.
There is one question quite commonly asking is that the serial number. Some people used to ask that is the serial number is to be 1, 2, 3, 4 like that for all the issues, or this is to be for every issue. Serial number means it is every issue you have to have serial number. You cannot have just like minute book, you cannot have like that. The
Exactly.
purpose of having a serial number is to understand, just by seeing itself, you should come to know, is it more than 200, less than 200? Yeah.
Now, application money and utilization.
Just 1 minute. Just go to the previous slide. In
Yes,
PAS
sir.
4, see, in PAS 4, when you are giving that, it's a kind of letter of offer come application form. Very surprisingly, in section 42 says that there is no right of renunciation. I don't know why they have to say this
Exactly.
thing. Very surprising it is.
Surprisingly, correct. Good, correct. Surprisingly,
If
I don't
rights
know.
issue, there is a renunciation right is there with the shareholders. If I am not able to apply, I can renounce it to somebody else. In case of section 42, on one side, you are saying that it is to be addressed to the identified person. Application is done to be identified person. Where is the question of renunciation? The question of renunciation is not there, but very clearly the section brought this particular thing. So it is advisable even in your PAS 4 also, bring this particular point. There is no right of renunciation is available. Yeah.
Anyway, see, I think they would have meant basically the downselling thing, but instead of that, they had used this word is what I feel.
It is superfluous, but anyway, since it is there in the section, you better cover it in your offer letter also.
Yeah, better cover it.
Okay. Application money and utilization. Now, only the person to whom the offer letter is addressed can apply for the security, and payment toward the subscription or security shall be made only from the bank account of such identified person subscribing to such security. In case where securities are subscribed by joint holders, the payment toward the subscription shall be made from the bank account of the person whose name appears first in the application. There is no right of renunciation in private placement. Company shall open a separate bank account within a scheduled bank for such issue. Money in this account can only be used for allotment of security or refund where allotment is not possible. The application money can be utilized by the company only after return of allotment, that is Form PAS 3 is filed within 30 days of allotment. Now for allotment, by way of board resolution, allotment within 60 days of receipt of application money. If it is not allotted within 60 days, then refund needs to be done within 15 days. If failed to refund within the next 15 days, then interest will be charged, that is 12% per annum will apply from 61st day. New security cannot be issued on private placement unless the security in the earlier issue are allotted.
1 second. So one more thing, Sudhakar, I just wanted to point out is there is always, I think, please, friends, let's understand this private placement or whatever, preferential, whatever you call, it is based, the 200 number is based on the offerees. In the sense, if you are making a offer general offer to so many people and don't think that only I have allotted to 50 people. The answer is no. The offering also should not be to more than 200. That be mindful of that fact. I think always this, अरे किधर लिखा है allotment तो मैं इसी को किया मैं, why should I, but please the offering. Secretarial auditor should take care of this.
Very good point.
Okay.
Go ahead.
So next slide. Now, as our allotment is done, post-allotment compliances, file return of allotment within 15 days.
Just 1 minute, Khadija.
Yes,
See,
sir.
Ranga, what you have mentioned, that is, though it is correct, actually, it should not happen. The reason being, the PAS 4, the letter of offer and application form is to be circulated to only the identified persons. So you have to circulate to less than 200 people or 200 or less. It cannot be to more. Suppose if I am issuing to 2000 people, how can I do it? I cannot even issue that because only those people to whom I have issued the application, they can make the application. No one else can do that. So it is already tightened that as far as there is no scope to do any hanky-panky there.
No, but
Sir,
that
it's happening. It is happening,
right.
Sudhakar.
Is right.
It is
People
happening.
argue this way. Yeah.
And go to section 42(7) or subsection. That is why they are saying no notice, circular, advertisement. So Bala also mentioned sometime about the fintech. I am aware of a fintech company which has brought, it's a private limited, not even a public limited, had bought so many guys and and that even the fintech, that company was also penalized heavily by ROC. So that is why it's still happening, sir. No, you are very right in saying it has been it's been tightened, but still it happening.
Sudhakar, theoretically you are right actually, but practically the situation is actually different. That is where the ROC is taking left and right. As Raghunath rightly pointed.
Yeah, go ahead, please.
Okay.
There have been instances of cases where the people have been actually penalized. Yeah.
Post-allotment. Now, while filing Pass 3, return of allotment, within 15 days, a complete list of allottees need to be filed in that Pass 3 in Excel file. So what are the details? That is full name, address, PAN number, and email ID. Yes, sir.
1 minute. What I want is you don't need to read the entire slide. You say that Pass 3 is to be filed. That itself is sufficient.
Okay.
Whatever the details are there, they are there. Okay. Otherwise, what will happen is because there is so much of we have to give the value addition, you will not be able to complete your presentation in 2 hours time. Okay. So wherever you have to skip, just say Pass 3 is to be filed along with the prescribed particular. That is sufficient.
Okay.
Yeah.
So now, while filing Pass 3, we are also required to maintain a record in Pass 5. Then the stamp duty payment needs to be done. And we need to issue the certificate within 2 months or 6 months of allotment as the case may be. And necessary entries need to be registered in MGT1 or MGT2.
Now, Sudhakar, Dipti especially, Dipti now, go, just, Khadija, if you could just go back. Issue of share certificates in today's scenario, even private limited company shares have to be in demat mode. I don't know, we need to, don't go with this, share certificate has to be issued only in 2 months and other things, friends. So be careful of this, though
small companies are still there. That's it.
That's okay. That's maybe that's the only thing.
That is this.
Another thing is there when you are actually filing the Pass 3, although the details, etc., even the minor detail which are left out, what happens is it is actually equally penalized company as well as certifying secretarial auditor also. There have been cases where some information is actually left out and secretarial auditors just certified it. Both of them are actually penalized. So one has to be very careful on this. So Sudhakar puts it at the very beginning only. All the checklist ensuring compliance, that is a must actually. Yeah. Go ahead, please.
So there are some do's and don'ts. Subscription money can be paid through check or demand draft for other banking channels, and no cash payment is allowed. No media advertisement to the public for private placement or security under private placement cannot be allowed to any other person other than the identified person. Now, what are the penalties of contravention? Contravention of section 42, that is towards the company director and promoter, that is raised up to 2 crore penalty, which is low, whichever is lower, plus refund of money with interest within 30 days of imposing penalty, and default in filing of return of allotment, that is Pass 3, that is a penalty of 1,000 per day, and maximum is 25 lakh.
I think one minute. Go back, Khadija. See, very surprisingly, this is the only section, I mean, to my knowledge at least, where for a procedural matter, the promoter is held liable. Contravention of section 42 is a procedural matter. How come the promoter is to be held responsible? I fail to understand that. Company directors, I can understand, but very surprisingly, contravention of section 42, who are responsible? Company directors and promoters. Similarly, defaulting filing the return of allotment, who are responsible? Company directors and promoters. Not specifically they mentioned about compliance officer. Of course, he will be held responsible. That is under different section. That is a different thing. But under the section, very surprisingly, why the promoter has been roped in, I don't know. But having said that, the promoters are also to be careful here that they have to ensure that they are not indulging in any kind of penal consequences because of the non-compliance of the rules by the management.
So that only place where I feel I just have to just recollect my memory under section 34 and 35, the civil and criminal liability in case of misrepresentation in prospectus is the only place where it could come.
I agree there, because it is the promoter's responsibility as far as the prospectus is concerned, because he is the person who is bringing the public issue. Whereas in this case, section 42, why promoter is to be held responsible? I really fail to understand it. Anyway, I agree with you that, as far as prospectus is concerned, that is there. Correct? Yeah.
No, these are all some of the small tips that, we as compliance officer or maybe from a practicing side, if you are guiding, we should guide the management in all these things. And that's the reason I think these things are being discussed.
Maybe, Sudhakar, this is a raising of funds. Public issue also is a raising of funds. This is another way of raising of funds. And you both mentioned how this section has come and how promoter play a role in marketing and bringing the investors. Because it is first they decide, the investors have talked, marketed, then they agree. Maybe that is the reason.
See, Dipti, in case of private placement and the preferential issue, normally promoter has nothing to do with that. In case of public issue, of course, promoter has to do it. Say, for example, private placement, where is the question? Where is the promoter? It is actually the CFO and the CEO. They require funds and all. They decide that let us make a private placement. They approach the board of directors and board of directors approve that. Then the procedure starts. Promoter has no role to play here at all. And you don't need to give any details of, something like that of promoter don't need to give any kind of affirmations or lock-in. Nothing is there. IPO is entirely a different ballgame in comparison to private placement. That is the only reason why I mentioned how they have want promoter. Maybe the regulator or the legislator have their own way of looking at it. Having said that, so one has to be very careful that they should not put the promoter who has nothing to do with the private placement in trouble. Yeah.
Now, we will move to a preferential issue of shares and securities, that is section 62. So here we will cover any other group of person, that is person including employees, members or employees, either for cash or other than cash. Preferential offer. Preferential offer means any issue of shares or securities. Yes, shares or security is equity share, FCD, partly convertible debentures, but it does not include NCD over here.
Yeah.
By a company to any select group or group of person on a preferential basis, and it does not include right issue, ESOP, sweat equity, bonus share.
Okay. Only one thing, Sudhakar, if you had seen this previously, before these rules came, even under the 56 regime, of course, it did not have so many things. People used to ask this very peculiar question of, I'm passing a resolution, board is passing a resolution, and it also goes to the shareholders under 81(1)(a), so for a public issue, is it not a private placement? Should we not? Now, I think that's one reason, while even in the company law review committee, when this was discussed, that's one reason the public issue has been very clearly come out in one way. I feel it's a good one that the public issue has been mentioned very clearly. But I do not know why bonus shares are also covered. That's a different issue. Okay. Go ahead, friends.
Now, issue of share on preferential basis, there are certain conditions that it needs to be authorized by the article of association. A special resolution need to be passed in the EOGM general meeting, and complete allotment is required to be made within 12 months of the special resolution. And if the allotment is not completed within the time frame, the approval lapses and a new special resolution will be needed to proceed with.
Okay. The only word of caution here is to all of us, is that whenever, see, most of you might be incorporating companies day in and day out, please try to include one clause in the articles about the preferential issue of shares. I think many of us forget to include this, and later on when the company wants to do this, we just run about and then, we blame V3, we blame everybody. But please, this is one thing, whenever it's possible, whenever you are incorporating a company, please ensure, we don't see that actually, please ensure that this particular clause is also covered under the article. This is a very important thing. And don't think that, one more thing I will also take this opportunity to mention here is, whenever you are issuing even preference shares, that also is required to form part of the articles. Don't say that, my authorized share capital takes care of it. No question of arguing, friends. Now, since you're all helping a lot of companies incorporate new companies, ensure that this is taken care of adequately at that time itself. Yeah, Kadir.
Now, Rule 13 of Companies Share Capital and Debenture Rule. There are certain 13 items in the explanatory statement which need to be annexed to the notice. I will quickly go through 3 or 4 items. That is objects, total number of share, the basis of price determined by the register valuer, the proposed time that within which the allotment shall be completed, and the name of the proposed allottee and the percentage of post-preferential offer capital that may be held by them after the issue. And if there is any change in control, then that need to be mentioned.
Yeah. 1 second, Sudhakar, which you very validly raised one point about the penalizing the promoters. Now, if you look at here, intent, the 7th one, intention of the promoters is also being talked about. So is there a linkage? So intention of the promoters. Now, board is separate. The promoters may not be, so maybe this is also one of the reason why that penalization ho sakta hai, is what, when you read this. Okay.
Now, the price of the share or other security to be issued on a preferential basis, either for cash or for consideration other than cash, shall be determined on the basis of valuation report of a register valuer, where converted.
Sorry, my apologies. Please, can you go back to this one, to the earlier slide? See, we are now talking about the unlisted space, friends. Last point, if you see the change in control, please, friends, whenever, I come across people, whenever I ask them, is control defined in Companies Act? The first answer is no, it is defined only in SAST. Please, friends, it is defined very clearly into subsection 27 of Companies Act. Please resort to that. Okay, be mindful of that. Because every now and then, most of, so they feel it's only in SAST that talks about control. I just wanted to give a small, please go ahead.
So what you said is, if I'm not wrong, control is defined under the Companies Act also. Am I correct?
Also, yes.
So here control is as far as the Companies Act is concerned.
Absolutely.
Yeah. Okay.
So where convertible securities are offered on a preferential basis with an option to apply for and get equity share allotted, the price of resultant share pursuant to conversion shall be determined by the basis of 2 points. That is either upfront at the time when the offer or convertible is made, and at the time which shall not be earlier within 30 days to the date when the holder of convertible security was entitled to pay for the share.
Okay, just to put it in simple terms, friends, you are determining the price. We saw that in case of a preferential offer, other than the debt instrument under 42, we need to have a price determined by a registered valuer, right? That's one thing. That in case of equity shares, it has to be determined upfront. And even in the other case, convertibles, if you feel no doubt you should, you should decide at this juncture when you pass the special resolution saying that, am I going to fix this convertible price at this juncture, or 30 days prior to this? Condition of fixing it should be very clearly stated in the explanatory statement that you are talking about. I think the pricing, as far as convertibles are concerned, there is an option to the the holder of the convertible securities to to have a price 30 days prior to the date of conversion. So that flexibility has been given here. It was already there in the ICDR, and of course 2013 May this has been covered. So, but it should be stated upfront in the special resolution. Please be mindful of that. Don't think that convertible, I'm going to determine at a later date, so let me do it at that stage. The answer is no. Yeah.
Now, where the shares or other securities are allotted for consideration other than cash, then the valuation of such consideration shall be done by registered valuer and shall submit a valuation report to the company giving justification for the valuation. In case where a non-cash consideration is involved, it need to be treated in the following manner in the book of account of the company. There are 2 points, that is in the form of a depreciable or amortizable asset. And where clause 1A is not applicable, it shall be expensed as provided in the accounting standard. Now, the valuation report shall be made by an independent merchant banker who is registered with the Security and Exchange.
One second, Khadija. I think last paragraph you very clearly mentioned there is nobody. It's only the register valuer who has to give. So you can skip this. Only a register value has to give. Pehle wo tha merchant banker, but it is not the case. Please go ahead. Next slide. Yeah.
So this is the step-up plan for issuance of share on preferential basis. Just a procedural thing. So I will quickly go through it. We need to hold a board meeting for private issue of securities and finalization of pass for approval of notice of EOGM. Then a separate account needs to be opened. Convening of EOGM for the following purpose, that is pass resolution and for approval of passport. Then an MGT 14 is required to be filed. A private placement offer cum application in the form of application serially numbered. Then a board meeting will be conveyed after the allotment is received, and pass 3 needs to be filed within 15 days.
Okay, I'll just take a pause. I will also talk on listed entities, Sudhakar, either here itself, because I think it's been elaborated very minutely about different aspects. Only 2 things. Whenever the board, or the management conceptualizes the idea of coming out with fundraising, especially through a preferential issue, it takes much earlier than when it hits the board. So there is a time gap, and especially listed company, this is an UPSI. First thing, whenever you decide this, please put it in SDT is the first one. Second thing, as we spoke, appointment of a registered valuer is just putting some points, Khatija, before, where you have started, just 1 or 2 points for listed entities. Then the third one is advance information to the stock exchange under regulation 29 is what just wanted to just put those 3 points in case of a listed entity. Okay, one more thing, since you are done, before I forget, for a listed entity, friends, I think most of us, of course, now there are a lot of learnings, and I'm seeing people are following very clearly, Deepti and all, now under ICDR, there is a provision saying that in principle, an application for in principle approval has to be done the same day as you post the mail the notice. I'll tell you, 2 years back, many people were not reading this, and many issues, had come to me for just for some clarification as to how do we do it, friends. There is I'll not say there is a way out. Initially SEBI exchanges were taking a small lenient view on this. When you apply to exchange in turn tells you to apply to SEBI. Now there is no question of, they will give you, because they post action, so things are over, so they will give you, but you will be penalized heavily. Please be mindful of that fact. So when you do a checklist, please underline and do this, things. Is what is my thing. It's you will never be able to read very clearly this. On the same day it says, please checklist may be dal dena. I think first thing what I tell people is first to put this now. Don't forget.
But Ranga, last week we had a bonus issue discussion. That point of time, also the same thing, and what you have mentioned now. You have to have a permission in the articles of association. You need to have that. In fact, I have given an example also. One company secretary has put the bonus issue declaration, resolution, and all those things. And one director has pointed out, in your articles, there is no authorization. How can we do this? Then the company secretary got panicked and all those things. He was not able to understand how to remedy that issue. So what happened was that particular chartered accountant, the director is a chartered accountant friend of mine. He called me and said that, is there any way out? So I said that you have to amend the articles by way of a supplementary resolution, call extraordinary general meeting, where this particular thing, anyway, you are doing it. So anyway, blah, blah, blah. Those things I have already discussed with the participants last week. As you rightly said, in principle approval, articles of association provision, these are certain things which one has to be very, very careful about this. Whichever the issue it is. Yeah.
Okay, so now as we completed with the Companies Act for Section 42 and 62, we'll
I think,
proceed with
Bala,
ICDR.
can we take some questions now? Because now actually that we are going to ICDR. Before that, if any questions not answered, you may take up.
Yeah, sure, we'll do that.
Quickly, because we got another 45 minutes and ICDR is a very big subject as such.
So the same thing, I think, Sudhakar, somebody is asking, each and need to open and close separate bank account after each and every placement round. Can't we keep on using the separate bank account for all such private place rounds? I think we have been
answered already the question.
You already got the
elaborate.
answer. You cannot do that because you have to keep a track of each and everything. That is why even include the serial number he has answered. Okay, let us start the question here.
No, somebody is asking previous special resolution once in a year is sufficient for QIB only, or okay, it is only for QIB. It's only for QIB. Or can we make preferential issue to other identified based on this based on this resolution? It's only for at least in a listed space. It is only for QIB. Is very clear. You can go to that slide, Khatija. You can answer this.
I will give one more clarification here is that there is a provision under section 42, unless until the previous issue is closed and allotment takes place, you cannot open a fresh issue. This is actually based arranged out of Sahara issue only. But please remember that if this particular provision is with regard to a particular security, that means if I have issued equity shares, I cannot come with another issue of equity shares unless until the allotment has taken place for the previous issue. But when my equity issue is in progress and I want to bring a preference issue of preference shares or issue of convertible the debentures or whatever it may be, that means the moment the security is different, then there is no issue at all. There is no problem at all.
Yeah.
Yeah, absolutely, you're right, Sudhakar. In fact, there have been cases also where the previous private placement issues were not closed. They have gone ahead with ROC has taken very heavily and penalized them. That is there. Okay. Let us start with the question. Sir, can you please interpret the provision of 30 days?
Where is it? What's the question?
Can you please interpret the provision of 30 days?
30 days for what? Sorry.
I don't know. Probably initially that related to some filing or something like that, I think so. Because there's an initial question which has actually come.
I don't know about what 30 days. Sir, can you interpret the provision for 30 days? 30 days for what?
Yeah.
Under which?
We can go next day. Next question.
Next.
Okay. In case of the issue of the share consideration other than the cash, what are the pre-considerations we have to keep in mind? So
considerations that we have, I quoted 3 different examples. Please don't do those things. That's the first thing which you need to consider. The second thing is the register valuer is also a very important thing that you need to keep in. Yes. I think that they are there. And in fact, if it is a valuation, the register value will take care of what are the different financial, valuation methods that are required to be done. The only thing is, so maybe, like in IPO, you can ask him to compare with a peer review comparison. That's the only thing which I can think of when you talk about. But as compliance officers or as company secretary, let us be very clear as to what could you allot, shares against for consideration other than cash. Can we open offers simultaneously at one time, like Preferential Series A, Preferential Series B? As Sudhakar rightly mentioned, and the act is very clear, friend. Sartha, somebody has written. It's very clear saying that it is each security. You need to identify it with each security. So if it has different terms and conditions, it tantamounts to different instrument, because ultimately you're also going to show that each one in the balance sheet, in the schedule has to separate thing, right? Then somebody is asking.
So
Yeah,
yes, Company Act 2013 allow issue of the share warrants by private limited.
1 second. The concept of share warrant, which was there in section 114 of the Companies Act 1956, has gone away. First and foremost, please understand. Today, it is only warrant that is, talks about. I don't think Companies Act mentions about what is warrant except in Schedule 3 as a part of your capital sources of funds. And that too, by mistake, I would see by mistake, they have used the warrant, share warrant. So the Companies Act allows, because private limited also can issue, because there is no bar now. There is warrants, but it is not share warrant, please. Maybe for colloquial understanding, we can use that word, but share warrant as such, as a concept under section 114 has gone. It never lived up to this, expectation, even in the 1956 Act. Okay.
A company wants to purchase shares in the another company.
Oh,
Can it
both, yes,
actually
sir.
pay the consideration?
I have told a lot of examples are there. In listed space also, a lot of examples are there. You can swap of shares is allowed.
Okay. Can share be allotted against the available bar following the private placement route via under section 42?
Just ensure acceptance of deposit rules, etc., etc. You can do even for listed entity. You can, unsecured loans.
I think you already answered also.
Answered this. Correct.
Yeah. The law is not very clear whether the separate bank account is to be. This, I think, we discussed enough actually on the separate bank account.
I think enough discussion took place on that.
Yeah, that is right.
Whether the allotment, I think we need to have some. Whether allotment can be done through power delegated to the board committee. Come on. Anyway, let's.
What is that? Allotment?
No, can the allotment should be done only by the board or by a committee?
That section 179 is clear.
No, that is for issue of securities, Sudhakar. This is
I'm talking about issue of securities only. You are talking about allotment.
Allotment. Here it is allotment. Allotment. So, but I don't think this. Anyway, you can do it. That's all the answer is.
Yeah.
Okay, yes, the company is newly incorporated, date of incorporation 12/1/24, and no financial has been actually made. Please clarify whether valuation report is required for this in this case.
Yeah, where is it?
If the company newly incorporated, that is date of incorporation 12/1/24, and no financials has been actually made, please clarify whether valuation report is required in this case.
I'm not able to see that question. Then I'll be.
No, the question is appearing after that. The law is not very clear where separate bank account. Below that,
Achha, 1 second. 1 second. Dekh lete hain na. 1 second.
It can be answered, Ranga, without even looking into the
question. Even I think, the very clear till the date the company has been in existence. I think you need to do a valuation. That's all.
See, not only that, valuation is not based on the fixed assets of the company. Valuation is based on the projections also. So valuation certificate is very much required. Okay. Even if for a new company also, valuation of the shares is different methods of valuation is there. One of that thing is about the future business also. So definitely how the valuer is going to value that company and its worth as far as the share price is concerned, it depends upon him. But you need to have a valuation certificate.
Absolutely. So valuation methods encompasses so many things, so many things.
Yeah.
It need not be only tangible assets. You know,
Correct.
so that's the thing. That's the thing, net point. Now, very peculiar question, somebody, will companies raising money through Shark Tank not be covered under Section 42 and as it is marketing and releasing of public? Please understand, Shark Tank is basically, they are going and saying whether you will be interested in investing in this kind of a business model that I have. So if I'm the guy who want to invest, I invest on a private placement basis. Those 2-3 guys will come. So you are complying with all the things. You're not offering it, your product, you are only marketing the product. Here, it's not the issue that you are marketing. I guess investors are brought by the promoters' influence. Maybe, that's the reason promoters are, have been, in case of.
It is just like a roadshow.
Because there you can't say, because I'm not offering anything to anybody.
Yeah.
Previous special resolutions once in a year is sufficient for QIB only, or can we make the preferential issue in other identified person based on this particular resolution?
See, as far as unlisted entity is concerned, I think it's only one resolution, that's valid for 1 year. But when it comes to what do you call the ICDR, it is completely different. Let me just explain at this stage itself on that aspect, friends. So when it comes to a listed space, you have to distinguish one thing, Sudhakar, if time permits, I also want to cover, which is not in this presentation, is again, in terms of a preferential issue, we talked about only private placement preferential issue. Now, for a listed entity, within that preferential issue, you have got two things. One, preferential offer, and private play or preferential offer through QIP, that is qualified institutional placement. The regulations are slightly different in both the cases. So if a company is passing, a listed entity is passing a resolution under 62(1)(c), if it is for a preferential offer, the validity of that resolution is, the resolution is valid, only for, you have to make an allotment within 15 days of passing of that resolution. 15 days allotment has to be done. So once that is done, that resolution is no more valid. You need to again pass another resolution. That's the first thing as far as preferential offer under the ICDR is concerned. But when it comes to QIP, the qualified institutional placement, where I place only with the QIBs, where the resolution is valid for a year, not even a year, it mentions about 365 days. Small difference. It mentions about 365 days. And I can do that QIB. For example, I pass a resolution for raising, say, 500 crores. It's like your shelf prospectus. But don't compare that with, I'm just giving a small analogy. But if you have a qualified, if I'm passing a 500 crores, and if I feel that the institutional investors' interest is only to the extent of 100-150 crores, and that is what I need at this stage, I can do that. And also the gap between two QIPs within that resolution that the shareholders have approved under 62(1)(c), the maximum gap is only 2 weeks. So after every 2 weeks, you can do it. Initially, it was 6 months. Then there was later on an amendment to ICDR, which now talks about a gap of 2 weeks between two offers under for if you are doing a QIP. So this is the answer to this.
Sir, in PAS 4, what to be the investor bank account details is to be mentioned. In case the investor transfers the funds from different account, then the one mentioned in the PAS 4, this will amount to the non-compliances, right?
Yes, it amounts to non-compliance.
It is. So one small thing somebody is asking, if you are allotting securities on private, do we also have to give reference of 60 in such an issuance of? Again, are you talking about NCDs purely under 142? There is no need. But if you are talking about a convertibles, you need to mention both.
Okay, next is again 4-5 placement the opening account that you already answered. What is the meaning of identified persons?
I have already explained that.
Okay.
Board has to identify.
can offer letter and it is acceptance be signed by way of the DocuSign?
What is it?
Is the offer letter and the acceptance be signed by DocuSign?
I think there should not be a problem. Even these days, ESBA applications are also accepted. I don't think any issue is there in that.
Whether the allotment can be done through the power delegated to the board committee, that I think you already discussed that. Can convertible note be issued other than the NRI under the private placement, since the same is not covered under the Companies Act 2013 and governed by RBI guidelines?
But RBI guidelines also will talk about this convertible note as a security, right? There will be some reference of convertible note to. Now, what do you mean by a convertible note? Again, is it a security? I think it will be a security in all probability. It will be a security. The only thing is, since it is, if you are issuing outside of the country, and that's why RBI guidelines are also in place. Convertible notes as such, ultimately you need to go to the definition of securities under SCRA and see whether it fits into this definition. Yes, I feel it will definitely fall under the definition of securities. Next, Shark Tank answer kar liya, sir. Bala sir.
Yeah. Will the companies raising the money through the... Yeah.
That's done, Mr. Bala.
Okay. I guess investors are brought by the promoter that you talked about it. In case of the refund of the huge body, that also is there. We are allotting the security in the private placement basis. Do we have to give preference of the section 62(1)(c) in such?
Oh, done. Bala sir, done. That's also answered.
Is it relevant to applicable private placement where the concept of the relevant database derived is not mentioned in section 42 rules? Is the relevant date applicable for the purpose of the company where the concept of the relevant date derived is not mentioned in section 42 rules?
Okay, let me put this way.
Only in ICDR.
Sir, relevant date is there even in the Companies Act 62. When you talk about, see, why is a relevant date required, friends? I think let us understand the instrument that we are offering. NCDs, private placement under section 42 covers NCDs also, where you don't need a real valuation that it depends on, the different interest yields that are prevailing in the market. And based on that, company fixes a particular rate of interest for NCDs, right? Now, hence, in that case, there is no concept of a relevant date. Whereas in case of convertibles and equities and convertibles, you have a valuation methodology, you have different financial valuation models to be applied, and hence, the share price or the enterprise value might differ from date to day. And that's the reason relevant date, we need to have like a record date or a cutoff date in case of convertibles, and hence relevant date has come only in 62(1)(c) read with the rules, and that too in the rules. Of course, ICDR always had this relevant date right from day one. Okay. Hopefully the people hopefully the people who have raised this issue are still there and listening to us.
Yeah, mostly all are there who are raising.
Yeah, mostly everybody is there.
Okay.
During the issue of the convertible securities, for example, CCD, we can actually issue FP at ₹1 lakh, and then at the time of the conversion, we will actually require the valuation report. Is this understanding is correct?
One second. Let me read. Where is it? One second. Huh? Good questions, but we'll answer. We can issue at face value of 1 lakh, and then at the time of conversion, we'll require valuation report. Okay, now let me put this way. Yes, you can issue CCDs now, but the valuation report, yes, you can do it because there is a, you are given a flexibility to, fix the price of the equity 30 days prior to the conversion date, and hence you can do that. But what the Act requires you to do is mention the formula, whether are you fixing this price upfront or are you going to do it 30 days prior to conversion is what is required. You can do at that stage, because if you are actually mentioning it now, it doesn't make any sense to convert it 30 days prior to the date of conversion. Yes, that's allowed. Can a company secretary in areas of fundraising क्या है दीप्ति आपके लिए है?
Can a company secretary in practice areas of fundraising activities only? What is the scope of the same?
No, please. We'll take a separate session for this. Let's avoid this. Come on.
Please differentiate between the private placement and the preferential basis. I think you have talked enough on this.
So, chalo, sir, this is what I started saying, that still people are, again, please, whoever has raised this, please be aware. Private placement is a broad umbrella. Preferential offer or preferential placement is only with respect to equity and convertible securities into equity. Whereas if you want to issue NCDs under the private placement route, Section 42 talks about it. So private placement is a broad umbrella. Within that, you have preferential offer of equities and convertibles. And, in case of a listed entity, you have further in preferential offer, you can give it to identified persons and also separately only to QIBs. I think this is more than enough for anybody to understand.
If a resolution passed approving the private placement, if money is coming in the installment, can we file multiple pass 3?
Dipti, aapke liye hai. But this has come, sir. Recently, somebody was asking this.
For issue of NC.
One second. If a resolution is part approving, money is coming in installment, can we file multiple pass 3? I think the answer is no, because what do you do in case of unless you are calling it, I don't think in a listed entity all these things have to be fully paid up. Please understand. So there is no question of doing this. And secondly, in case of an unlisted entity, I don't think the section anywhere states about it should be fully paid up unless I have missed out.
No, it is not there.
It's not there. So there is a possibility of equity shares being called up in parts. If that is the only case. So now tell me, even in case of in a normal situation, Sudhakar sir, Dipti, you can just tell me, in case of we do have calls in arrears, and whenever we call for the remaining one, do we actually file something on that? I've forgotten. Do we actually file something, Dipti, at that stage?
Nothing.
No? So we can't have multiple pass is what I believe with the strict interpretation of this.
For issuance of NCD, special resolution is not required?
I think Sudhakar had explained in detail, boss. I think enough. Can offer letter and documents be signed?
That I think there's the same question again. It has come again.
Allotment to made to can another allotment to same one, similar.
Allotment made to 150. Can another allotment made to same 150% is the same, or I allowed to actually break the limit of 300 and 200%?
So very, very simple. Identified persons. I think we talked at the beginning, and also continuously we are talking about the identified persons. Identified persons can be the same, but in the same, is the instrument the same? That's the thing that you need to talk about. That doesn't go with the identified person. It goes with the instrument in your financial year. I think the act is clear. No, I think, I very clearly covered under, trade payables. Can you repeat this, Acha? Can you repeat this? No consideration other than cash. You cannot allot shares against trade payables. I think answer is simple.
Non-filing of the FCGPR funds, inflow from a parent company in UAE and subsidiary in India. Please explain the impact of such non-filing of the FCGPR if such a non-filing remains for the period of 2 years from the date of the funds inflow.
I think, Dipti, you need to have a FEMA.
This can be because next.
Valuation report is related to the valuation report. No, that I think you talk about it. NCRT, again, the same question is repeated. If the conversion is actually exempted deposit unsecured loan from the directors or relative directors related to shares and considerations other than the cash.
See, simple. Unsecured loans today, if you look at acceptance of deposit rules, I think it's very clearly, unlike in the what do you call acceptance of deposit rules of 1975, here it is very clearly said, even in a public limited company, if at the time of converting this loan, at the time of giving the loan, if that director was in place, if that person was in place, you can convert that loan and give shares against that, even that is allowed even in listed space, friends. So that is allowed. That is allowed. If valuation report on shares needs to be received from chartered
accountant. That are compulsory from a registered certified valuation professional.
I think we go and please read section 247. Who can be a registered valuer, please?
What is the meaning of the cash? It means the check. Please clarify under the professional allotment.
Sorry to say, friends, it looks like, we are posing questions in WhatsApp groups, No, because these are the things,
Relevant date, I think you already answered that relevant too.
So relevant date, again, relevant date is nothing but I'm fixing a particular date because I need to determine the price of my equity share. Today, can I determine February 1st, May, or can it go back to March 31st, 2024 is the question. Normally, I take a particular date. It's like a record date or a cutoff date that is required for me to do it. Hence, that relevant date, normally it is 30 days prior to the shareholders meeting. That's all. That is the relevant date. We can do ESOP is being done. What is that?
ESOP is being done. I'm not able to get it. What is it?
Even I'm not.
I don't know what is it.
No. Maybe we might be thinking that I said, right? Like employee salaries, I'm not able to pay. I'm allotting shares to them. No, ESOP is governed under a different. The principle of ESOP is completely different, friends. Please. Again, another group, WhatsApp group. Sudhakar sir, another WhatsApp group question. Can allotment of securities be done through circular resolution? Can we convert unsecured loans? Yes.
You mentioned about committee, issue and allotment. That's why that parallel question.
See, you can authorize the compliance officer of the company to allot the shares. Not even a committee required.
Can we convert unsecured loan?
Oh, okay, sir. Okay, Bala sir. I mean, next in case of non.
Can we convert the unsecured loan of the directors into equity? That you said.
Yes, spoken. Yes. In case of non.
In case of the non-resident applicant from whom valuation report is required to be obtained in private placement and preferential issue.
I'm not understanding this question, so could be better wordings, but I didn't understand. And that too, it talks about from whom the valuation report is required. Valuation is not to be required from the investor, friends, please.
Can you please go through whether the securities of the debenture issued in the right issue? Yeah, you already said here. Okay. If money is received in tranches, can we do multiple?
No,
that also you said you answered actually. How can the requirement of the receiving at least 25% of the consideration before the allotment met when the valuation at the time of the conversion? This is actually contradiction with the allotment of the convertible warrants.
No, even warrants, when you fix a price, let me tell you, even in case of warrants, when you fix a price today, based on the equity shares price, you arrive at something about that to fix, but the flexibility is being given to it because the difference you may have to make it at the time of exercise. Today, when I have to collect 25%, I have to give either the face value. So I'll put this way, either you call the face value of the warrants, or if at all, if you had making an equity calculation at this point in time, based on that, put very clearly the difference needs to be paid at that. I think the most interesting question, I like this, Sudhakar sir.
Yeah, I agree with you.
This is the most interesting, whoever has raised this. Thank you.
So it's like that, if it is convertible security, when you are issuing that security, at that juncture, 25% of the face value. But there are two options. You decide the price of the equity in convertible security at the time of issue or at the time of conversion. So if you are at the time of issuing deciding the price of security to be converted, then you have to take 25% of that total amount. But in later stage, if you are deciding, then you cover up the difference of 25% at the time of exercise of that option, right?
Yeah.
I think we are done with the questions. Now we can move.
One second, last.
Yeah, sorry.
can the relevant date for valuation be 60 days or 90 days? It is 30 days very clearly mentioned. That's all. Okay.
Yeah.
Yes, now this ICDR phase, this is again another 30 slides are there. We cannot do this today.
Yes.
Maybe we have to close this particular discussion here itself, and we have to request Ranga again to make it convenient whenever it is convenient to him. We will hold another webinar for the ICDR regulation. So, which date will be convenient to you, Ranga? You please let us know. Next week, is it okay with you?
Next week, no. That's what it's 15th possibility.
Okay,
there,
please.
but
What I request you, please check up and put me a WhatsApp message, then we will hold it accordingly. Okay.
Yeah, nice. In fact, I want to suggest, Sudhakar, good. You also realize this because it's a very interesting topic as we saw. A lot of other questions also will come, and good that we are bifurcating this into listed and unlisted. So
correct.
that, I also want to cover on QIP, Sudhakar, because there is a story behind that, and all this, listed space, there are a lot of stories also.
So please let me know your convenient date, then we will hold that webinar accordingly. Okay.
Ranganathan, for your information, even if you see now the participants are around 154, that it
Sir,
shows what is the importance of the topic.
177 it has reduced. I saw 177 sometime back.
Yeah, even it has gone to 199.
Okay.
But the thing is, since Dipti raised the issue in the beginning, in the budget day, many people will not be interested and other thing and all. I'm talking at this particular time also, people are there very much, about 150. So that itself shows the importance of the topic and interest.
Yeah. Good, sir.
Okay. Good. Then thanks, Mr. Ranganathan. And again, we will have the next session for ICDR. Friends, at that time, of course, budget will not be there, and it will be very interesting to know. As you know that so many questions, so many practical inputs by our esteemed panelists. Thanks a lot for your inputs, Mr. Ranganathan.
Thank you.
Thanks, Ranga.
Thank you, Sudhakar. Thank you, Mr. Bala. Thanks,
Ranganathan.
Khadija, for your presentation.
Bolo, sir.
Ranganathan, exemplary. It is once again, very nice listening to you with your valuable practicality.
Sir, we are blessed. Atul Bhai is showing his face. So
sorry, I know I was into some other Zoom meeting.
He want to say he has come to say bye to you.
No. Wonderful. So I was there, for some time, but wonderful, Ranga. I can understand, kind of a passion you have, something very similar to our Sudhakar ji, and our Mr. Bala. The discussion goes on, probably, and people want to, listen to them on a regular basis. Anyway, thanks, Mr. Ranga.
In fact, Ranganathan, there were many things which I did not read actually. There are people who have appreciated. They have listened to you earlier on this topic. They very well recall your topics earlier on this. Those sort of the appreciation also there in the chat.
That you should have shown me, sir. I also didn't see.
It was there in the beginning when you were actually talking about it. Somebody referred the particular session also. Yeah.
Okay, I could not see those things. So
You're great, Ranga. You're great.
No, everybody is great, sir. Everybody, it's only the experience. See, in fact, for the first time, I'm seeing some presentation and I'm talking. This is the first time I'm doing. Otherwise, I'm not a PPT guy. You give me any topic without PPT, I'll manage. So that's the thing. Good. At least Khatija, thanks to her, she has prepared very meticulously and had taken all these relevant things. I would say almost the sections rules I don't think she has missed out any of the things.
She has definitely done a wonderful job, and my special appreciation to her actually. In fact, very nicely she has put it. Yeah.
Well, only thing is, when I meet her next time, I'm going to ask questions on this to her.
Oh, sure.
Okay.
Thank you, everyone.
Thank you very much.
Next week.
Thanks a lot.
Look forward. Yeah. Thank you.
Thanks, everyone. Thanks, Sudhakar. We'll catch up.
Thank you, Sudhakar ji. Thank you, Bala.
Thank you.
Thank you, everyone.